Migrating to Australia, the podcast where the migration titan, Mr. David Bongiorno, analyses all the issues that can confront a new arrival, a visitor, someone looking to make their life here. I'm Grant Williams. I'm not the expert. Today we've got two experts, but before we press on, just a note. All the information contained within this podcast is general in nature, should not be taken as specific legal advice, and if you take it as specific legal advice and act accordingly, David, what are you?
You're a donkey, Grant. How are you, mate? You good?
Mate, you got that bit wrong. You're a drongo or a galah.
This was for overseas listeners.
Yes,
Saturday
David.
afternoon. We've got Paul Cott joining us today. Now, Paul is up in beautiful Ballarat, and Paul's going to talk to us about employment law. Paul is the principal solicitor Law On Lydiard, and he has his own podcast that we'll get Paul to talk about later in our podcast, because Paul's podcast covers everything but immigration law and family law. It covers everything else, doesn't it, Paul?
It covers everything else bar criminal, family and migration, really, yeah.
Beautiful, yeah.
Very good.
Yeah. We were talking before, Grant, about Paul's producer is one of the judges for the podcast award. So I was saying to Paul that he should put his in as well.
So that's what I'll be looking at this afternoon.
Beautiful, beautiful. Now, I think Grant is frozen, but that's okay. I wanted to talk to you, Paul. We help a lot of people come here as temporary migrants and permanent migrants. And the first job they always have, doesn't matter if they're arriving as temporary residents, or sometimes when they arrive as temporary residents, they have a fully fledged job. But if they're coming as students and then they're progressing through the system from student to graduate to temporary resident on a work visa, permanent resident, proper six-figure, five-figure, full-time, responsible grown-up job, the first job they always have is casual, always. Now, can you define what casual means? Can you explain it to us in lay terms?
Well, a casual employment job is one where the employee has control over the amount of hours they work and what days and times, and so does the employer have that flexibility. It's as opposed to a full-time permanent or a part-time permanent. So basically it works on the basis of the employer needs a workforce or the employees for a certain period of time and certain days, not a full-time basis, calls them up or maybe sometimes still rosters them on for a week or 2 weeks, and it's on an as basis. So I suppose you could describe the relationship between them as on an as needs basis between the employer and employee. So a casual employee, there's no definition as such in the legislation, which creates difficulties, and because a lot of the time what people call a casual, they're actually not. They're actually really a full-time permanent employee who are entitled to sick leave and annual leave, but they're not getting those things. They're being treated as if they're casual, but in reality they're full-time. So there's a bit of a mismatch there, and there's some rights that employee may not be getting because of that situation.
Somebody arrives and they arrive as a permanent resident or they arrive as a student on a temporary visa. How will they know if, in that scenario you just raised, how will they know if they are casual or actually full-time permanent? What do they need to look for?
So, well, they need to look for, obviously they get an employment contract. Obviously that will be one hint. There's not always an employment contract. They'll also look at what the parties call it. If the employer says you are casual, then they're probably casual. Also, if the employee thinks or regards themselves as casual, then they may well be casual. But then you actually look at the reality of the relationship. Are they on regular and systematic hours? And now that terminology, that phraseology, regular and systematic hours, is what is used for the Fair Work Commission or the courts to work out when someone has actually in reality converted over to full-time. Are they regular and systematic? And they can put an unfair dismissal claim in if they have been regular and systematic hours for a certain period of time, minimum 6 to 12 months. If they are, so they're doing the same hours every week with slight variations because the things come up, but regular and systematic hours is basically another way, I suppose, to describe full-time hours, whereas casual hours, it could be 1 hour, or it should not paying you not 1 hour, 3 hours a day, 4 days a week, 1 hour, one day of 8 hours, 1 day, 2 days, 10 hours. So there's a lot of variations in the amount of hours. So if you get a lot of variations in the amount of hours in the days, then you're probably casual.
There's a great power imbalance with the casual employment relationship, isn't there?
Oh, without a doubt, because an employer, and I've advised employers to do this. If an employer says, well, I don't really like this person, they're casual, for example, unlawful, I don't like them because they got blonde hair, they just don't give them shifts. So that's discrimination, what I've just described. Illegally unlawful discrimination. You can't not employ someone for the colour of their hair, for example, and you just don't give them any more shifts. And the employee says, oh, I haven't got any more work lately, and the employer says, there's no work here.
There's nothing they can do, is there?
No.
Paul,
That's it.
Paul, can I ask you about what happens when you first start a job? Should you always get a contract or a very clear set of responsibilities and tasks associated with the role? And when you get paid, is it a requirement that you are supplied with a pay slip? And what information should, by law or by regulation, should the pay slip have on it?
So I'll start off with the second question. Pay slips are mandatory, no matter what the employment. If it's an offence under the Fair Work Act, where the employer can get subject to a penalty if a pay slip's not provided. So it's an offence. They have to do it. And I think the regulations just basically say, they're not very prescriptive, but they just basically say they're supposed to set out the rate of pay, any entitlements that should be there, accrued entitlements, how much I get paid, how many hours, and what the dates are, and the name and address, and something like that.
Should it make a note? Should it make a note of what the award or what the conditions are that you're employed under, so that there's no misapprehension by either party?
It won't say the terms and conditions because they're pretty basic one-page documents, but it will specify an award that they're under, supposed to. And, of course, then the employee can look at that payslip and say, oh, well, I've got a query surrounding some term and condition, am I allowed, how much annual leave I'm entitled to, whatever it might be. And then they can look at that award and check out whether they're getting paid correctly or whether they're entitled to how many leave and how much annual leave.
But the awards aren't simple to read, are they? So there'd be a lot of misunderstanding. If someone's coming to Australia working casually or their first full-time job, you almost need to be a lawyer to read some of those awards.
Oh, look, there's no doubt about it. In fact, even lawyers, including myself, find it hard sometimes to read the awards. And when I say that, it's across the board because most of the awards are now standardised. So they've reclassified and amalgamated a whole series of awards into, I think, a certain amount of what they call modern awards. They're very hard to read. And you look at one thing and then you've got to try and find what you're looking for. They're all over the place. And sometimes I had a query this week, well, what's the minimum rate of pay for me? And it wasn't in there in black and white. And you had to look at the one clause, you had to look at another table, and then you had to look at something else. I really understand they're not easy to read. The other thing about an award, even more common issue that I've dealt with is which award is an employee covered by. Hardly any employees know. If you ask them what award covers your employment, hardly any employees have any idea. Well, and some employers don't have any idea what awards their employees should be under.
Well, that was the point of my question about what should be on the pay slip. There should not be any confusion every time that you are paid. Even if you're paid directly into the bank, there should be either an email with a pay slip, or you should be given a actual document that serves as a pay slip. There shouldn't be any misapprehension. And if your employer is telling you or making up all kinds of reasons why they can't give you a payslip or can't identify the award, it's time to start looking for another employer, isn't it?
Well, it is. And I had an issue recently where the employer said, well, how much am I supposed to pay these people? And in the back of my head, I'm thinking, how can you not know this? You should know. You should be on top of this. You need to be telling the employee what they're entitled to, not the other way around. It's just, I completely agree. That's completely untenable, unacceptable. And when I said there's complexity about which award applies, sometimes even I've had employees ring the Fair Work Ombudsman, who's the body to get that information from, and depending on who the call, the receiver of the call is, you'll get a different award. And some of the duties overlap, and potentially there's more than one award that could potentially apply to your employment. But, you know, the bottom line is that if you make a reasonable choice as to which award applies, then you should be okay.
A lot of people get pressured in their first job or their second, even their third job, to take cash in hand. Can you tell listeners the danger of taking cash in hand?
Well, from a record-keeping perspective, as lawyers, we like to keep records, but employees should keep their own records. If you're getting cash in hand, it may be that the tax obligations are not being complied with. It may be that there is a potential issue of that cash that they're getting is, in fact, not sufficient, so there's an underpayment issue. It keeps it off the books. It might be that the reason the employer likes to give people cash in hand is because they are not au fait themselves with their employment obligations and what is meant to be paying people. There's a lot of little risks all around with that, and it could then come down later on to a dispute between the employer and the employees to how much was paid.
And no recourse for people with cash in hand, is there, because of the absence of records?
That's right. It might just come back to say, well, you gave me 800 and, well, I'm entitled to 900, and the employer says, well, I gave you 920. In fact, I gave you above the award. Then if there's no records, then you've really only got one person's word against the other, the old she said, he said situation. And that's what we don't want to be in, because anything can happen then.
You had any matters in those of late? Any he said, she said scenarios? How'd they pan out?
I've got a matter ongoing at the moment that's to do with a lot of employees who are underpaid and some inadequate record keeping. And a lot of these people were hospitality workers, which is an area where this type of stuff is rife. And a lot of these people have now left the country, were casual. Some of them were only on trials. Some of them were there for a few hours and then came and gone. And a lot of them, there's no records. It's just really hard, really difficult to reconstruct what the true situation should have been.
Sorry, Paul, go on.
And I was going to say that it's uncommon, but it's still out there, is that there was a view in that case that the fact that the employer gave the employee some free meals and paid meal breaks, more to do with the free meals, well, then we can underpay you a bit, or we only pay you a flat rate, for example, because we're paying you for your meals. Well, it doesn't really work like that.
Paul, if someone's just started a job, let's say in hospitality or in a very small retail operation, or, I don't know, labouring on a building site, probably a building site's not a good example because most of them are highly unionised. But if you're doing, let's say you're doing the casual, the dog's body work, the Man Friday, for want of a better term, for a landscaper or something like that, two guys in a ute and a trailer, something like that. And the boss has said, yeah, I'll give you a contract. Yeah, I'll give you a position description. Yeah. Didn't happen after the first week. Didn't happen after the second week. Didn't happen after the third week. When is it reasonable to expect to get it? And if you don't get it, are you bound by any terms of a so-called contract?
Well, when is it reasonable to get it? It should be given, I think, within a reasonable time after the commencement. I think that's what's actually legally required. So really, to me, that means probably within the first 3 weeks maximum, you should get those documents. Sometimes what I've noticed, and probably not with your two men in the ute, for example, but a lot of the time you'll just get a letter of offer. The employer will just give the employee a letter of offer, which sets out some of the terms of the employment, and then they might then say, and a formal written contract will be supplied in due course, and then that never happens. And the parties continue on, they don't worry about it, they let it go, and then a dispute arises as to some of the terms. So when you say there can be no terms of the contract,
well,
how do you work out?
Well, I guess what I'm asking, I've got two of the sharpest legal minds in Victoria here. When I did contract law, there had to be an offer and an acceptance for a valid contract to exist. So if you get a letter of offer that tells you that a contract will be forwarded to you, have you actually accepted anything even if you start work?
Well, I think you have. Courts can always be very ingenious in constructing the terms of a contract. So you can accept the terms of the contract by conduct. There will always be, if you can construct all the communications together, a court will often offer an acceptance and intent to relate to and create legal relations, and they'll construct key terms. Somewhere along the line, the court would be able to work it out in that scenario, even though there might be nothing written at all. In fact, most contracts are formed by no writing. And the example I wouldn't give is go and buy a newspaper. There's no written contract. Go and buy a book from a bookshop. There's no written contract. Most of the time, when people enter into contracts, which we might do 10 times a day, there's nothing in writing. But you can always construct some of the terms, and there'll be implied terms as well. So even if the party didn't turn their mind to things, the courts can say, well, the parties would not have contracted on the basis of other certain terms being as part of the bargain, and so they would be implied, even if the party didn't expressly say it or turn their mind to it. So those contractual requirements like offer and acceptance, we taught in law school, as you said, that those things are required, but in reality, people don't order their affairs that way. We just we do it in an informal way, and you go and buy a sandwich and say, I just want this, and that's your contract. And the party leave.
A lot of people will be too nervous, their first job here, to take a matter to court. How can they prepare themselves? What opportunities exist to resolve something before court?
Yeah, well, that's a very good question. And you know what? The reality of it is that most of these types of matters don't go anywhere near a court. There's many other options you can resolve it. I did mention before the Fair Work Ombudsman. They are the body that, if there's unpaid entitlements, queries, questions surrounding rights and liabilities at employment, give them a call. So the Fair Work Ombudsman, and not to be confused with the Fair Work Commission. So for some reason, the Commonwealth Government saw fit to put two bodies into existence that both regulate employment law, called the Fair Work Ombudsman, and one's called the Fair Work Commission. And then I had an inquiry this morning, actually, where someone rang up and said, I have a matter in Fair Work Australia, which doesn't exist anymore. So it's very confusing. So if there's unpaid entitlements, you can go to the Fair Work Ombudsman. They can give you advice. You can do mediation through them. They can issue determinations. And then, if needs be, if the monetary amount at stake is worth it, then you can go to either the small claims division of the Magistrates Court or the industrial division of the Magistrates Court. But most of these issues to do with underpayments do not end up in court, do not go anywhere near it. So there's various options. The first option you want to do is to say to the employer, look, I think I might be getting underpaid. What can you help me? What do you say about it? They might say, well, I don't think I'm paying you right. Then you might have a HR department. That employee might make an inquiry through there. You've got community legal centres. They sometimes can give free advice to people who fit their criteria as to rights and entitlements. In reality, most of these matters, people do not need to go and see a lawyer. It's not worth it.
A lot of people will be scared to approach their boss lest they get sacked, fearful of contacting HR lest HR tell their boss. What words do you have to encourage them to overcome their fears? What rights do they have in this scenario as employees?
Well, for example, if the employee said, I think I'm getting underpaid, and the employer says, no, you're getting paid correctly, and there was a bit of a dispute and a bit of argy-bargy, and the employer got a little bit angry with the employee for raising their rights, and they then sacked them, for example, or reduced their shifts, or even cut their pay down even further, the law does provide remedies which go to the Fair Work Commission. Again, the Fair Work Commission deals with employment disputes. So that would be what's called probably an unlawful adverse action claim, and it remains in the Fair Work Commission, and most cases resolve there, where that type of claim is based on, well, I exercise my workplace right to make a complaint or inquiry about my employment, and because of that, you did such and such adverse action against me, whatever those things might be, and you lodge a claim, and it's a $73 filing fee. You don't necessarily need lawyers for that process, and the Fair Work Commission does a mediation or a telephone conciliation, where I think the statistics are around the 90 to 95% mark for settlements at that stage.
Not bad.
Yeah.
It's good.
Paul, what if the employer gave a slightly different answer and he said, oh, no, you're being paid correctly. You're getting nothing because you're still on trial.
Oh, yeah.
How long can a trial be valid for?
Well, in my opinion, a trial is not valid.
Beyond an hour. We lost you there we've lost you. We've lost your sound.
I can hear Paul. Are you there?
Yeah, I'm here.
Yeah, we're back.
Yeah. We're back. Beautiful. So how long an hour?
Oh, an hour max. Unpaid, that is, yeah. An unpaid trial shouldn't go more than an hour. You should be able to work out whether someone might be suitable for parole within an hour anyway. And technically speaking, they should even be paid for that hour.
So
a lot of chefs and cooks get a shift, an unpaid shift, don't they?
Yeah, well, I've heard of that. And look, I'm not overly cynical type of person, and I say, well, that type of thing is probably decreased, but it does exist out there a little bit still. But an unpaid shift is not lawful. Simple as that. Not a whole. You don't need to do it. You don't need to look at someone for that long. That's the reason why you have casual employment, because it might be that the employer reasonably says that the employee wasn't a good fit after an 8-hour shift of paid work, and then doesn't give them any more shifts if they're not suitable. So, yeah.
I spoke to somebody I know quite well who started working in a restaurant, and the standard practice for everyone there was to do a shift on trial. And when asked why that was, because the boss couldn't be bothered ringing the referees of anybody. So I don't care if someone says they can adequately do everything that's required. I want to watch it first.
Yeah, that reminds me and puts into my mind the scenario of I can't remember his name, George, and then starting with K or C. I don't know the circumstances.
Hang on, I've got to mark that because I'm going to have to take that out. Let's just substitute famous celebrity chef who is selling a house in Toorak.
Yeah,
the 25-minute mark.
Yeah, and it might be that there's other instances where some of the public underpayment issues with various employers around Australia, some of them may involve paid shifts. As well.
Let me just jump in on something I remembered. Paul, you probably haven't heard all the episodes of Migrating to Australia where I've railed against celebrity chefs who have the business model of taking their employees' rightful earnings away from them. I was watching on the ABC breakfast show the other morning when they crossed to their finance person and they were talking about the state of the economy and the scorecard of where the dollar is against this and iron ore on as they do. Is iron ore in front of silver in the last quarter? Who knows? But, recently in the COVID times, they've all been stacking their books up so you can see what they're reading and what's on the back shelf. Rockpool was there a noted compliant employer.
Yeah.
Sorry, I just couldn't let that one go. Heston, they're all in it. I think good on Gary Meehan for not for being scrupulously fair. I guess at the risk of tarring everyone with the same brush, though, Paul, if you're in hospitality and you don't have a contract and you're doing and you've done a trial that lasted more than an hour and you're not getting a payslip, the chances are that you'll be involved in a class action down the line.
Well, look, possibly, but the Fair Work Ombudsman's got a big role in those types of things. Has prosecuted, and when I say prosecuted, I don't mean criminal charges, but are getting back some of these underpayments. So the Fair Work Ombudsman's got a big role there. The free telephone advice service who also take actions on behalf of employees, and they do, and they run these actions hard.
Good.
Some of the first jobs people get these days are Uber delivery driver, Uber taxi cab driver. Are these guys and girls who take on these very difficult but very important jobs contractors or employees?
Well, that's another issue altogether, isn't it? Because they're either a casual or a contractor or maybe even a full-time employee if they're doing regular and systematic hours. I think some of these issues have been litigated recently. I think that the federal court has recently made a determination about some Uber drivers. I don't know if it was Uber Eats or if it was some of the other Uber services they provide. But
Deliveroo, employee, Uber Eats, employee. I'm trying to think there was another one. I think it might have been Menulog, employee. Similar situation in London, employee. The tide's turning.
Well, you're describing situations where, unfortunately, it looks like people have been taken advantage of in that, let's take on this guy and we won't treat him as an employee because, again, we don't have to pay him annual leave or superannuation, take tax out of his pay and all that administrative stuff or work cover. Don't have to pay work cover premiums. And let's just treat him as a contractor, which basically means that he's running a business in his own right. If you're treating someone as a contractor, they're in their own business. So they might have an ABN. I had earlier this year a matter where a worker had been in a business for 9 years. He had an ABN. He could come and go as he pleased. He was not subject to the direction of the employer. And what you do in those situations is you throw in a whole number of factors. The court often said, well, on the balance of all these factors, which one overrides all the others? So it's a really difficult determination. That case went away because we resolved it. But to me, that would have been line ball. There's often a very fine line between a contractor and an employee. And the issue has gone to the High Court on more than one occasion. And I think there was a case called Hollis and Baboo back in the 1980s, which went to the High Court purely on that issue amongst bicycle couriers. Went to the High Court, and I think the High Court came down a certain way, but the way that the majority of the High Court came down was opposite to what the majority judges along the way had determined. So you might have say 6 appeal judges and decision judges had said one way, and then you've got 3 High Court judges saying,
whose house is about to burn down?
My home office is about 8 feet from the laundry. It's my washing machine.
It's the laundry.
I was trying to be poker faced and let it go away.
Paul, what was that case?
Hollis and Baboo. So HOLLIS and versus Baboo, VABU. And that was the first time the matter went to the High Court in Australia back in the 1980s at some point. What
a lousy book. It's not in it.
No, it won't be in that one. And there's been other cases where that issue in itself has gone all the way to the High Court. Is this person a contractor or an employee? Because often it's very difficult to determine. And it's an area that's ripe for exploitation of people.
And that's the problem with people with their first job. They generally, it doesn't matter what they do, you'll always have, it doesn't matter which country you're in, first-time employees, even kids, Australian kids in their first job, they get taken advantage of. So it's why they need to know what they can and can't do, and why we do a podcast like this. Do you see many people like that, or are they sort of not sufficiently financial, not sufficiently versed to come and see you? Do they just let it go and walk away? If they do, what do you say to them?
Well, I think most of the time the issue doesn't get to a lawyer. I would say that most of the time the issues are getting resolved by people making inquiries through the Fair Work Ombudsman or various bodies like that. I also think that some people just don't know. They just don't know that they actually might be an employee where they're getting treated like a contractor. They just go along thinking everything's fine. They don't even consider the issue. They don't even have any inkling that there might be an issue that their classification is incorrect. And the classification incorrect has real consequences. You know, that if you go there for 10 years, and I do know one person who has been at a business for 5 years or so and has never had paid annual leave. So when it comes to Christmas time and the business closed down for 3 weeks, she doesn't get paid. Now, she works 10 hours a day, 5 days a week. And
in a profession, a trade, a service?
A professional service.
Jeez.
And she is so clearly an employee, it's not funny, and yet she doesn't get the entitlements an employee would get, and she is treated as a contractor.
And she doesn't want to rock the boat?
Exactly right. She doesn't want to rock the boat. She'd rather go along as it is now rather than say, well, this is not acceptable, and then put her employment in jeopardy. And that's the issue with a lot of people, is that they find it hard to raise these issues because they don't know what backlash is going to come their way. Now, the law has all these claims that you can fall back on, such as general protection disputes and claims to the industrial division of the magistrates court. But in the end, the employee may have lost their job, and it's only got a legal claim, which may or may not succeed, to fall back on. And that's really unsatisfactory, not a great position to be in.
Paul, in about 10 days' time, the special conditions that have allowed companies, not businesses, to trade while insolvent will come to an end. What will happen, do you think, with employees who may find that they've been underpaid recently and that they commence an action in October or November? Is that provision of trading while being allowed to trade while insolvent going to mean that employees who have been underpaid during the COVID times won't be able to get the money owed to them?
It could mean that. So I think there's been extensions to some of the laws allowing companies and directors breathing space in relation to insolvent trading. But the protections are there, but they're just being put on hold for 6 months or whatever it might be. So it can make it harder. I had one case where an employee got a judgment from the Federal Circuit Court that the employer pay 20 grand in unpaid entitlements. He actually got a judgment. And the company director just put the company into deregistration. And the employee is not going to get a cent. He's given up. And before it went into deregistration, the company director said, even if I could or would or wanted to pay this debt, this company's got nothing. It's a shell, and I'm about to close it down.
And then Phoenix it, probably.
Yeah, without a doubt that he'll be operating under a different name somewhere else.
A very similar name, with a very similar logo in the same shed or the same...
Out of the same house,
Yep.
doing the same services.
Yep.
So that's a really difficult position for him to be in. And
Paul?
yeah,
Sorry, go on. Sorry.
that company probably traded while it's insolvent. Insolvent trading claims are not able to be litigated by the average man in the street because we're talking legal costs of 20 to 30 grand.
That's right.
It's too much. It's too much, yeah. Paul, a lot of people who listen are young people who want to come and study in Australia. Now, you're an adjunct lecturer at the College of Law, so you see young lawyers coming through the system every day or every week. What would you say to those who want to come and study law in Australia? What tips, what hints would you give them?
Yeah, that's a good one. That's a good question, that. Look, I think we've got an imperfect legal system in Australia. I think there's a lot of opportunities for young lawyers in Australia. Even if you get a law degree and get admitted to practice, you don't have to practice law. You can use your degree for other things. There's a great support network out there who like the mentoring thing. So I do a little bit of work through the College of Law called under the umbrella of the in-practice mentoring program, where instead of at the moment law students are finding it hard, or people who just about finish their degree finding it hard to get work placement, they've got an in-practice component where the student talks and gets a bit of a relationship under a mentor program. So I'd had 4 students a few months ago who we communicate and go through a few exercises together, as in, trying to replicate real life. And then they've come back to me and asked me certain other things down the track. Just, I'm getting one this week, said, I'm having a job interview tomorrow. Can you give me any hints about this job interview? So I gave her some free, advice, some tips, and she went away and did her interview, and I'm waiting to hear back. So there's the legal profession has a lot of people who are willing to help out for free because they're quite collegiate, and I am. I said to the whole 4 students who I mentored under that, I think we basically do 3 weeks of a program. I said, if you ever have any other issue, even if it's 10 years down the track, hopefully I'll remember you. I haven't gone senile and gone out of my mind. But if you would ring me up and say, oh, Paul, do you remember all those years ago you mentored me under the College of Law in Practice mentoring program? I've got some issues here. Can I get your thoughts? And I said, I'm happy to help you out. Not a problem. So we've got a good collegiate support network in Australia for people who studying law.
Paul, what do people, I can't think of the Sydney, Pitt Street, I think. What's the story with this obsession a lot of younger law students have with Collins Street and Pitt Street? What are they missing out on by focusing almost exclusively on the top tier firms? What are they missing out on job-wise?
A hell of a lot of opportunities, which may well be much more rewarding from anywhere from the small practices like my own, being a sole practitioner, all the way up to in between. And I think what they're missing out on, to cut to the chase, if they do go and work in those top tier firms, is they're missing out on a life.
That's a good one. Very true.
And work-life balance is a term that's bandied about a lot these days, but it's a real thing. And it's actually a real thing. I also do assessing through the College of Law. I spoke to a student a few weeks ago, and I said, well, what have you been doing? She said, I'm in my first 6 months of my grad program in one of those firms, and she's been stuck in a room going through documents for the last 6 months.
Agony.
And that's it. But she's happy with that. That's good. Maybe some people are happy with that. She perhaps didn't know any better, but she's happy with that, and she knows it's not going to last forever. There are better times ahead, and she's looking forward to that. But she's happy doing that. But that's what could happen. And there's a saying as well that some of those top-tier firms will, even though you're a law graduate, they want their pound of flesh. They'll work you hard, and you may have to 10, 12 hours a day, 5 days a week, and don't be surprised if you have to come into the office every now and then on weekends as well. So when I said you'll miss out on a life, that is the reality, that your social life will decrease. You get to the weekend and you're exhausted, and then you come around on Monday and do it all again. You might do that, might be happy to do that for a while, but you wouldn't want to do that for a long time because it's not sustainable.
Now, you've got a great podcast. How many episodes of Law On Lydiard Law have you got now? How many have you produced?
29.
Can you take us through some of the episodes that may be relevant to listeners today from the employment perspective?
Yeah, so the most popular episode has been on unfair dismissal. We also do things to consider when you're doing your will. We've also done if there's issues of bullying in the workplace. That really goes through a lot of the options that people don't realise that they have. We talk about if somebody owes you money, what are your options to get that money paid to you? We talk about the difference between what we talked about before. One of the podcasts is purely about the simple question of, are you a contractor or an employee? Fencing disputes.
Yeah, I was waiting for that. That's my favourite one. That's my favourite, the fence.
Yeah, sitting on the fencing dispute. So victims of crime, if you're a company director, so often relevant to a mum and dad who, say, for example, the husband has a building company and the wife does the admin work and they're both directors. What are your actual roles and responsibilities being a company director? Yeah, they're the ones that come to mind at the moment.
Can you give us your socials, your website, your podcast, full name of podcast, your full website so people listening can look at them?
Sure, no worries. So the website is www.lawonlydiard.com.au, and Lydiard is spelled Lydiard. And you might think, well, that's a strange name. Where'd you come up from that? How did you come up with that name? But that's the main street in Ballarat.
How far away are you from the town hall are you?
Oh, that's just around the corner.
Okay.
About 50 metres away.
So you need that hotel on that side street. Is that what's the street with the hotel that behind the town hall?
The big hotel, the Craig's Hotel.
Yeah.
I'm 2 doors from there.
Oh, I know where you are. Absolutely.
Yeah.
You're very central.
There's only one.
That's right.
There's only one landmark in Ballarat that you need to use as a reference point.
The town hall, man.
No, the Macca's. It's Baker's Hill, isn't it?
Bakery Hill.
Bakery Hill. Everybody.
And my last question, Paul, and this is an important one. Geography, when you're doing employment law, it's federal law, correct?
Yes, Commonwealth law generally, yeah.
Commonwealth law, yeah. So basically, anyone listening, doesn't matter where they are geographically, if they want to talk to you, they can give you a call, can't they?
Oh, that's right. In fact, I consult to a couple of unfair dismissal companies, and I never met my clients, never have, and I never will. Some of them are in WA, some of them are in New South Wales, some are in Queensland. I don't get many South Australian ones for some reason. I mean, I've had a couple in Tasmania. So, yeah, that can be anywhere. It's irrelevant where they are, really, in that type of stuff.
Good to know. Like immigration, doesn't matter where they are. We can help where we are. Doesn't matter where they are. That's good to know. And when I always have my last question, Grant's always got one or two up his sleeve. Grant,
I've got a double barrel question to end up with for Paul, but before I ask it, self-indulgent plug. Paul, I interviewed Paul a little while ago for a forthcoming new project that I'm putting together. So look out for not just another podcast, and you will hear Paul talking more about business rather than specifically about law. Paul, let's bring some sunshine back into all the doom and gloom that we've been casting about employers that do the wrong thing. In your experience, generally, how many employers are generally doing the right thing? Let's say a percentage. And what are the two most important things that somebody who is coming to Australia and is getting a job, has been offered a job, about to start a job for the first time, what should they look out for as a warning sign?
Yep. So the warning sign, if you mean when they've got the job?
Yes, and they're going along nicely and they're doing their job and they're getting paid, but if they haven't had a contract, and everyone else that they're working with hasn't got a contract, hasn't actually got a physical contract, and nobody gets pay slips, would that be warning sign number one, that you should perhaps look for a better employer?
I think not having a written contract is not that important. I think there's certain jobs that you'll never get a contract. So that's not as important. If you're not getting pay slips, that's a warning sign, a big one. And I think another warning sign might be if the pay is varying when the hours are not varying, and or if the pay perhaps is or becoming now starting to be paid late.
Yeah.
That's a warning sign as well.
Yeah. But most employers are good, aren't they? They do the right thing.
Going back to that, I would say as a percentage, in my view, about 98% of employers do the right thing.
Yeah.
And it might actually be even higher than that. Now,
that's good to know. That's good to know.
Yeah, look, most do. So, and that's probably maybe a bit of a surprise when you hear because I act mostly for employees generally, but particularly in unfair dismissal matters, I act for employees most of the time. And nearly all those claims are about things that the employer's done terribly towards an employee, or allegedly. There's always two sides to every story. So, but despite that fact, all the things that I hear and the horrible stories that I hear, and every one of them is a story in itself, I would still say 98%, if not higher, of employers do the right thing. And if they don't do the right thing, they may do the wrong thing for a period, but then they fix it.
Yeah.
So it's never conscious bad action. It's always something that they've missed or...
Yeah, so, I think it'd be pretty rare, really. Maybe I'm being overly optimistic, but I think it'd be pretty rare where an employer deliberately sets out to cheat the employees.
Yeah. No, they're the bad apples. We highlight them, but that's you can't fault an employer who is doing something wrong. It's drawn to their attention and they remedy the situation. That's a good boss.
Well, that's right. And the client that I mentioned before, with the many issues to do with people who are underpaid, they remedy the situation. They spent money remedying the situation and they remedy it. You know, people get a chance in life. Everybody does.
Paul, I do have one last question, actually. It just came to mind as you were talking about good employers and bad employers. What obligations, when an employee leaves, does an employer have to provide a written or telephone reference?
Yeah, that's a really good question because that comes up all the time and there's a lot of misunderstanding about that. So with an employer, there is no obligation to provide a written reference. In fact, most employers will just simply not do it now. They won't do it at all. And a lot of employees want it. There's a thing that's related to a reference, and that is what's called a statement of service. So in these unfair dismissal matters, one of the non-monetary outcomes you can often achieve at conciliation, and which nearly all employees want, and nearly all employers are willing to provide, is a statement of service, which is just a document on the employer's letterhead which sets out what the duties were, how long they worked there for. This is a simple factual outline. And most employees are happy with that. They don't necessarily need the employer to write down a whole lot of glowing terms. The other thing that sits beside that statement of service, and I was often referred to in it, is what's called a designated point of contact. So if a prospective employer did want to speak to someone and maybe probe into that form of employment a bit more, then there can be a designated person that the employee says to the prospective employer, you can call this person and they'll say some things about me. I think the genesis of this was a series of cases where, I'm not sure what time period it was, but where employers thought, well, if you want me to provide a reference, I'm going to have to be totally truthful as to my views, and then started to say some not so nice things about the employee, and they were sued. The employers were sued on the basis of, well, you've now prevented me getting this job. I've now suffered financial or economic loss. I'm going to sue you, Mr. Employer. So I think that may have been the genesis of now employers just do not provide written references, very rarely.
Paul Cott, Principal Solicitor, Law On Lydiard, podcaster. Get into those awards, mate. Your podcasts are a dream, and we'll promote them in the notes because what you're doing is very valuable. Thanks for being on Migrating to Australia.
It's my pleasure to meet you both. And Grant Williams, I must say to you that you're a great podcast questioner, because particularly my last one, the word that I got out of that was Grant Williams with his questions is very good at giving probing questions that really makes you think. So they're good.
And, well, thank you for that compliment there, Paul, even though I can exercise verbosity on occasions. But I'm not going to commit to supporting you in the podcast awards because we might be in the same category.
Oh, yeah.
So, and good luck to you if you could work out what category you're supposed to be in. I don't know what those guys must have been on acid or something when they put those categories together. Oh, my goodness.
I'll have a look at it, see what it's all about.
Yeah.
I think you should, Paul. I really do.
And there we go. I can't let go without a plug. If you like David and I on the Migrating to Australia podcast, or you like Paul on Law On Lydiard podcast, when it comes around to voting and sharing on socials and all that kind of stuff, get active because it makes a difference. Thanks again, Paul. It's been great been great to pod meet you for a second time. And, of course, you can contact David if you need to with a migration issue on David. There's your cue.
At David Bongiorno, all one word, DavidBongiorno on Twitter. Paul and I talk a lot on Twitter. I love Twitter. It's the fastest way to get in touch.
And, of course, all the links that we've been talking about, I'll probably have to put in all the ombudsman and the commission and everything in there. There's a lot of work for me to do this time. But the good news is the revamped, good-looking Migrating to Australia podcast website should be live by the time this podcast is live. So that's migratingtoaustraliapodcast.com.
Ken?
You too.